I believe in supporting people's decisions to profit off Pepe in order to provide them with the most positive business experience possible. I strive to be an advocate for Pepe in both love and enterprise and hope to help business people have an empowering and joyful experience while making an ocean of profits as limitless as the universe. According to plaintiff, this statement was made sarcastically. In another interview with New York Magazine in September 2016, plaintiff stated that he realized that Pepe is beyond my control. He's like a kid. He grew up, and now I have to set him free to live his life. Plaintiff also stated, I just sit back, relax, and let the Pepes fall where they land, my friend. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. This is Michael Fitzgerald, U.S. District Judge. His order regarding plaintiff's motion for partial summary judgment and defendant's motion for summary judgment. The plaintiffs and the defendants are Matt Furie and Infowars. This is the Pepe the Frog lawsuit. Before the court are two motions for summary judgment. Plaintiff Matt Furie's motion for partial summary judgment, defendant's motion for summary judgment, and there's some dates in there as when they all filed their replies. And the judge just goes straight into it that the Furie motion is granted in part and denied in part. Well, that doesn't tell anybody anything except to keep reading. As to the affirmative defenses of abandonment and de minimis use, the parties have presented conflicting evidence and summary judgment is inappropriate. So we're going to go further into the pre-trial and trial process on abandonment and de minimis use. So abandonment of copyright, I'm assuming, and de minimis use of copyright, I'm assuming. We'll take a look at that. As to the affirmative defenses of lack of copyright, invalid certificate of registration, implied license, defendants fail to rebut the undisputed evidence presented by plaintiff. So Infowars fails on lack of copyright, invalid certificate of registration, and implied license. Infowars motion is granted in part and denied in part. On summary judgment, defendants, Infowars, failed to establish no rational jury could conclude that Infowars was incorrectly named as a defendant. As in most cases, it is for a jury to determine whether defendants have proven the defense of fair use. Defendants have presented undisputed evidence to show that plaintiff is not entitled to statutory damages and attorney's fees, I'm guessing under 17 U.S.C. 505, which is the fee shifting provision, which shifts normally the parties bear their own costs. But in copyright, the prevailing party is supposed to have their costs granted to them by a judge. And we recently saw that they don't get all their costs granted. It's just their attorney's fees and other things. So this partial summary judgment means that Matt Furie doesn't get the award of statutory damages, only actual damages. On March 5th, 2018, plaintiff commenced this action. The following facts are based on the evidence as viewed in the light most favorable to the non-moving party, which is either plaintiff or defendant, where appropriate. November 8th, 2003, plaintiff first published an online comic book called Playtime that features Pepe the Frog as one of several characters. Pepe the Frog is not drawn in color in any panel within the comic and is typically depicted with large bulging eyes and multiple white dots in his pupils. On some of the front and back covers, Pepe the Frog is drawn in color and presented as having green lips and puffy eyelids. Beginning in 2006, Pepe the Frog appeared in a series of comic books called Boys Club that was published online and in print. Like Playtime, Boys Club featured Pepe the Frog as one of several characters. Between April and July 2007, plaintiff published in print Boys Club 1. Only one drawing of Pepe the Frog is in color, which shows him with green lips. He is also shown as having 1 dot, 2 dots, or 3 dots in each eye in various panels throughout the comic. He appears in 21 of the comic's 44 pages. On June 30th, 2008, plaintiff published in print Boys Club 2. Only 2 drawings are in color, etc. We're going to skip a little bit of this. Again, August 30th, 2009, Boys Club 3. September 30th, 2010, Boys Club 4. June 30th, 2016, Boys Club Collective Edition, etc. Here are some depictions of Pepe the Frog from Boys Club. Plaintiff describes the character as a chill frog dude who has a lackadaisical attitude and enjoys spending time with his animal roommates. Plaintiff stated, for example, that Pepe the Frog likes pop pizza and talking on his cell, and his signature catchphrase is, "Feels good, man." Plaintiff described the comics as celebrating the lifestyle of 20-something bros capturing their lives full of junk food, catchphrases, and bodily fluids with horrifying and hilarious accuracy. On September 1st, 2017, Plaintiff obtained copyright registrations for the various Boys Club comics. By 2008, Pepe the Frog became a widespread internet meme, appearing throughout social media, online message boards, and other media sources. He was commonly depicted with his "feels good man" catchphrase. By 2010, the meme phenomenon was kind of peaking for Pepe the Frog. One such meme was created by an anonymous user on August 17th, 2009, in an online forum, a picture that depicts Pepe sort of looking sad, and the handwritten words "not good man" appear in the upper right corner. In an online interview in 2010, Plaintiff was asked, "How about the people that actually crop out Pepe's face and use it? How do you feel about people remixing your work?" Plaintiff responded, "I don't really mind. I was like, it doesn't look the greatest, but I don't care." And when asked if he considered himself to be a meme creator, Plaintiff answered that he thought that Pepe the Frog took a life of its own, and that it's kind of an interesting phenomenon that, out of anything else in the comic, took off. Once Pepe the Frog became a meme, Plaintiff started to receive examples of works featuring the character, such as shirts, and did not feel any particular happiness or unhappiness about it. Rather, Plaintiff was just kind of witnessing it as a phenomenon. By 2014, famous celebrities such as Katy Perry and Nicki Minaj began publishing memes featuring Pepe the Frog, and users of online message boards began posting thousands of works featuring Pepe the Frog and calling them rare Pepes. In 2015, he was the most reblogged meme on Tumblr. Plaintiff stated that Pepe the Frog's popularity as an internet meme eventually turned into a financial windfall for him. The parties dispute the meaning of Plaintiff's statements relating to Pepe the Frog that were made in various interviews between April 2015 and 2016. Plaintiff believes that his statements made in interviews were sarcastic and a joke, or displayed pride for Pepe the Frog, while defendants believe these public statements showed abandonment of Plaintiff's copyrights. On December 20th, 2016, Plaintiff created his own visual work called Pepe in Blue Shirt, for which he obtained a copyright registration on September 1st, 2017. The image was reproduced further below. Plaintiff asserts that, beginning in 2015, white nationalists and members of the alt-right began associating images of Pepe the Frog with white supremacist language and symbols, Nazi symbols, and other offensive imagery. Throughout 2015 and 2016, other third parties continued to use Pepe the Frog in images depicting the character as or with then presidential candidate Donald J. Trump, alongside other conservative political figures. Around 2016, news media began referring to Pepe the Frog as a white nationalist symbol. In January 2017, non-party John Allen created the first Make America Great Again poster. The MAGA poster is a collage of several politically significant figures during the 2016 presidential election season. Pepe the Frog is featured. In the upper left corner, the MAGA poster is reproduced below. And this is the quite famous MAGA poster that had Pepe the Frog in it. In creating the MAGA poster, Mr. Allen used an image of Pepe the Frog that he found through a Google image search as his reference point. That image was not drawn by Plaintiff. Mr. Allen was aware of Pepe the Frog as a meme, but was not aware of Plaintiff's existence. Prior to Pepe the Frog's use in 2016 in the MAGA posters, Mr. Allen had not seen the character used for political purposes or associated with political figures. Mr. Allen then offered the MAGA poster to FSS to sell on its online stores, located at Infowars Store and InfowarsShop.com. FSS is the operating business for Infowars. They promoted the MAGA posters on the Alex Jones show, and several of FSS's customers commented on Pepe the Frog's inclusion. Gross revenue from the sales of the MAGA poster totaled $31,407.44. Plaintiff did not enter into any written license agreement with either defendants or Mr. Allen for the use of the image or character of Pepe the Frog. Plaintiff neither offered an express license to defendants, nor ever contacted or attempted to contact defendants for a license. Plaintiffs also never negotiated with defendants for the rights to use the image of Pepe the Frog in the MAGA poster. Plaintiff has, in fact, never communicated with defendants in any way. The parties dispute whether the alleged misappropriation of Pepe the Frog by far-right entities and defendants harmed plaintiff's ability to license the character. Other relevant facts: the character El Sapo Pepe is an Argentinian anthropomorphic frog that has existed since at least 1988, and shows featuring El Sapo Pepe were broadcast in Argentina and other Central American and Latin American countries since at least that time. Below is a side-by-side comparison of Pepe the Frog and El Sapo Pepe. Okay. They do definitely have some elements in common, not the least of which is being named Pepe. In the summer of 2004, plaintiff traveled to Tijuana and San Felipe, Mexico. Apart from this trip, plaintiff has never visited any Latin American country prior to creating Pepe the Frog. I think the judge is trying to establish that there's at least some evidence that maybe there was some inspiration for Pepe and that Pepe is not an entirely original design. But I don't think there's any other evidence, unless we're about to read it. I don't know. But other than what the judge just said, unless there's something more, that's all that the judge has to say about that. Plaintiffs object to some of the evidence on which defendants rely. Let's skip ahead of some of that because this is 41 pages long, and the judge overrules the objections. In deciding a motion for summary judgment, which is Rule 56 of the Federal Rules of Civil Procedure, the court shall grant summary judgment if the movement shows there is no genuine dispute as to any material fact, and the movement is entitled to judgment as part or matter of law. So that's the facts line up, there's no dispute in the facts, and judgment is something that the law would recognize. The Ninth Circuit has defined the shifting burden of proof governing motions for summary judgment. We're going to skip this. Basically, the non-moving party gets things in their favor, and when things look in their favor, if there's a dispute, then we go to trial on it, is basically what that means. Plaintiffs argue that there are no genuine disputes of material fact to preclude summary judgment on the affirmative defenses for lack of copyright, invalid certificate registration, abandonment and forfeiture, implied or explicit license, and de minimis use. In their first affirmative defense, defendants assert that plaintiff does not have a valid copyright in Pepe the Frog because the character was copied from El Sapo Pepe. In order to establish that the plaintiff copied a pre-existing work, a defendant must show the plaintiff had access to the prior work and that plaintiff's work is substantially similar to the prior work in both ideas and expression. Here, plaintiff argues that during his deposition, he has unequivocally denied that El Sapo Pepe was an inspiration for Pepe the Frog in any way, and that he had never heard of or seen El Sapo Pepe before this lawsuit. Plaintiff also argues that he could not have been aware of an Argentine cartoon character when the uncontroverted evidence shows he never traveled to Argentina prior to creating Pepe the Frog. Plaintiff therefore has met his initial burden to show his lack of access to El Sapo Pepe. At the hearing, plaintiff also reiterated these facts and added that defendants have not provided any evidence that El Sapo Pepe even left Argentina and became famous in other countries. In response, defendants argue that the timeline of Pepe the Frog's development casts doubt on his claim of originality. Defendants explain that Pepe the Frog was mostly a formless blob in 2003 and took on significantly more frog-like features in 2006. Defendants suggest that the only explanation for the changes is plaintiff's visit to Mexico, where Pepe the Toad was popular and plaintiff was likely to have seen the character. Defendants contend that the creation of Pepe the Frog when El Sapo Pepe was ubiquitous in Latin America is suspect and cannot be just a big coincidence. Defendants finally argue that plaintiff's claim that he had never heard of Pepe the Toad prior to this lawsuit is self-serving testimony, and that plaintiff perjured himself when he denied copying popular characters into his own artwork. At the hearing, defendants also pointed to numerous other drawings by plaintiff, Big Bird from Sesame Street, Freddy Krueger, Groot from the Guardians of the Galaxy, to argue that he was interested in cartoon characters and would have seen El Sapo Pepe. Defendants further added that plaintiff's visit to Mexico was likely irrelevant so long as he had access to the internet. Defendants have pointed to no direct evidence to show that plaintiff had access to El Sapo Pepe, apart from the fact that he traveled to Tijuana and San Felipe in 2004, if that can be called evidence of access. Defendants did not submit evidence that shows featuring El Sapo Pepe were broadcast in Mexico in 2004, nor do defendants offer any evidence to rebut plaintiff's testimony that he was unaware of El Sapo Pepe prior to this action. To the extent defendants argue that all that is required is that plaintiff had access to the internet, this argument is even more unsubstantiated than the one relating to plaintiff's 2004 Mexico visit. Indeed, Nimmer's analysis, this is Nimmer on copyright, regardless of previous definitions of the concept of access, a court should return to the first principles in ruling that the existence of a plaintiff's copyrighted materials on the internet, even on a public and user-friendly site, cannot itself, by itself, justify an inference that the defendant accessed those materials. Defendants' arguments are speculative at best. Summary judgment is therefore appropriate. Accordingly, Matt Furie is granted his motion as to the affirmative defense of lack of copyright. In their seventh affirmative defense, defendants assert that plaintiffs do not have a valid certificate of registration because inaccurate information was supplied to the Copyright Office when applying for copyright registration. The judge deals with that. Here's Pepe in Boys Club in 2006, 2009, and then Pepe Blue Shirt 2016. The basis of defendant's invalid registration argument is that plaintiff failed to disclose the Not Good Man image as source material, even though plaintiff had originally created and disclosed the black and white comic image. But in general, the failure to disclose that the registered work is derivative of an earlier underlying work should occasion rejection of the registration certificate only if the claimant was, for some reason, ineligible to register the derivative work. It is therefore unsustainable to allege that a certificate is invalid because it fails to disclose to the Copyright Office minor items containing pre-existing details. Accordingly, the Furie motion is granted as to the affirmative defense of invalid copyright registration. In their third affirmative defense, defendants assert that plaintiff's public interview statements indicate that he abandoned or forfeited some or all of his copyrights in Pepe the Frog. In copyright, abandonment is the intentional relinquishment of a known right with knowledge of its existence and the intent to relinquish it. Here, the parties dispute whether plaintiff's public statements are sufficient evidence to indicate that he abandoned his copyright in Pepe the Frog. Defendants argue that between 2010 and 2016, plaintiffs made numerous statements to various media outlets that he was happy about Pepe the Frog becoming a meme, that he was not bothered by rampant unauthorized use of the character, that he was aware of third parties making a profit, but did nothing to stop them, and that he had lost control of the character. In one example, April 12, 2015, plaintiff gave an interview to the Daily Dot where he was asked what he thought of people profiting off of Pepe the Frog. In response, plaintiff said, "I believe in supporting people's decisions to profit off Pepe in order to provide them with the most positive business experience possible. I strive to be an advocate for Pepe in both love and enterprise and hope to help business people have an empowering and joyful experience while making an ocean of profits as limitless as the universe." According to plaintiff, this statement was made sarcastically. In another interview with New York Magazine in September 2016, plaintiff stated that he realized that Pepe is beyond my control. He's like a kid. He grew up, and now I have to set him free to live his life. Plaintiff also stated, "I just sit back, relax, and let the Pepes fall where they land, my friend." In yet another interview in The Atlantic on September 13th, 2016, he was asked, "How do you feel about the way it's been adopted by the so-called alt-right?" Answer: my feelings are pretty neutral. This isn't the first time that Pepe has been used in a negative, weird context. I think it's just a reflection of the world at large. The internet is basically encompassing some kind of mass consciousness, and Pepe, with his face, he's got these large, expressive eyes with puffy eyelids and big, rounded lips. I just think that people reinvent him in all these different ways, and it's kind of a blank slate. It's just out of my control what people are doing with it, and my thoughts on it are more of amusement. Question: do you have any regrets about Pepe and not having more control over his image? Answer: I don't have any regrets about anything. I do my own thing, and if anything, it's been kind of interesting to see all the evolutions of Pepe. Yeah, no regrets. Defendants argue that after these public statements and interviews were made, plaintiff attempted to counter this negativity with positive depictions of Pepe the Frog and eventually killed the character. Defendants specifically point to plaintiff's deposition testimony. Question: so you said you killed Pepe? Yes. Is it accurate to say that? Yes. In 2016, yes. I'm not sure what the time frame was, but there were associations with that character, Pepe, that were frustrating me. Question: tell me about those. Answer: the attention in the public perception at the time became complicated. You know, the associations of Pepe got interwoven with some kind of neo-Nazi or alt-right agenda. He had become, in the eyes of some, a mascot for hate groups. Defendants argue that plaintiff's numerous public statements encouraging third-party use of Pepe the Frog cumulatively tell the world that he consents to the copying, modifying, and distributing of Pepe the Frog, even with commercial use of the character. Plaintiff disagrees and contends that he made clear statements in the public confirming that he owned and would enforce his copyrights in Pepe. Examples: plaintiff's statement that Pepe the Frog is copyrighted in an Esquire.com article in September 2016. Motherboard reported that plaintiff will aggressively enforce his intellectual property in 2017. Plaintiffs issued press releases indicating that he had expanded his enforcement efforts in September of 2017. Contrary to plaintiff's contention that there is no evidence of a clear, decisive conduct required to establish that plaintiff intended to surrender his rights to Pepe, the court concludes that there is a genuine dispute of material facts to preclude summary judgment on the affirmative defense of abandonment. As both parties recognize, whether plaintiff abandoned his copyright turns on his intent as evidenced by how his public statements should be interpreted. But on a motion for summary judgment, the court can neither determine plaintiff's credibility nor place weight on his competing public statements. Both parties have simply presented conflicting public statements made by plaintiff relating to his intent over his copyright. Defendants point to public statements that suggest one thing, and plaintiff points to public statements that refer to another thing. We're going to skip ahead. So they deny summary judgment on the issue of abandonment. Implied or expressed license. In their fourth affirmative defense, defendants assert that plaintiff gave the general public a license to use Pepe the Frog. It is undisputed there's no explicit license. So we're talking about implied license. The existence of an implied license is an affirmative defense to a claim of copyright infringement, and the burden of proof is ultimately on the party seeking to avoid infringement liability. The Ninth Circuit has confirmed that whether an implied license exists is a matter of contract law. As such, it is governed by state law. The party asserting the affirmative defense of implied license must therefore prove the same elements necessary to evidence an express contract: mutual assent, offer and acceptance, consideration, legal capacity, and lawful subject matter. Here, plaintiff argues that there was no implied license because there was no evidence of an offer and acceptance or consideration, basic missing contractual elements. As indicated above, plaintiff has never actually communicated to defendants. In opposition, defendants point to numerous public statements made by plaintiff as previously discussed. The court disagrees with defendants. Those public statements cannot constitute an offer made by plaintiff because they did not invite the performance of a specific act without further communication and leave nothing for negotiation. At the hearing, defendants pointed out the fact that a Creative Commons license exists and appeared to suggest that plaintiff elected to employ such a license for Pepe the Frog. But as pointed out by plaintiff, a Creative Commons license, typically denoted by a CC within a circle logo, is a specific contractual arrangement in which an artist deliberately gives up certain rights in his or her work. Here, there is no indication that plaintiff entered into a Creative Commons license, nor does Pepe the Frog contain a Creative Commons designation as far as the court can discern. So the matter of the implied license is granted in favor of Matt Furie. The eighth affirmative defense, defendants assert the use of Pepe the Frog was de minimis. A use is de minimis only if the average audience would not recognize the appropriation. Similar to the affirmative defense of abandonment, the parties presented conflicting facts as to whether the use of Pepe the Frog in the MAGA poster is de minimis. Plaintiff argues that the MAGA posters contain enough of Pepe the Frog for the average audience to recognize the appropriation, since the posters depict Pepe's entire face, bulging eyes, eyelids, and lips. Plaintiffs also point out that Mr. Allen intentionally made Pepe recognizable, and multiple customers, in fact, recognized Pepe in the MAGA posters. At the hearing, plaintiff repeated these arguments. Defendants contend that there is a lack of similarity between Pepe the Frog and the MAGA poster. Defendants point out that, among other things, physical characteristics like being green, having bulging eyes, and a human-shaped body are not unique characteristics to Pepe the Frog and are common to cartoon frogs in general. Moreover, the MAGA poster does not feature Pepe the Frog's entire torso. Taking the evidence in the light most favorable to defendants, it is clear that a genuine issue of material fact remains in dispute. This affirmative defense is therefore more appropriately left to a jury. Therefore, the summary judgment motion is denied on de minimis use. Then off to the Infowars motion, because remember we have two summary judgment motions. Plaintiff argues that the Infowars motion should be denied for failure to comply with Local Rule 7.3. This is I don't know what Rule 7.3 is, but they would bring a motion for summary judgment addressing solely the issues of fair use and lack of copyright because of alleged copying of the Argentinian character. But defendants now brought three additional issues. In opposition, defendants contend that during a telephonic conference, they indicated they would also move for summary judgment and possibly statutory damages, declaration of Mark Randazza. Defendants, however, acknowledge that their basis for seeking summary judgment as to Infowars' status as a defendant was not raised during the telephonic conference. Although it appears that the parties failed to meet and confer in strict compliance with Local Rule 7.3, it does not appear the plaintiff has suffered prejudice, and the court will allow it to proceed. Defendants argue that there is no evidence to suggest that Infowars engaged in any conduct alleged. Infowars is an intellectual property holding company that does no business of any kind and does not operate any websites. Rather, FSS operates the business at Infowars.com and other related websites, etc. The court disagrees that there is no evidence to suggest that Infowars was incorrectly named. Alex Jones, the manager of Infowars, publicly displayed and advertised the MAGA posters for sale. The websites where the MAGA posters were advertised are Infowars and PrisonPlanet.com, and they listed Infowars as the owner and operator. Defendants point out that these are mistakes, as the sites are operated by FSS, and Infowars has no involvement in the operation of these sites. Accordingly, the Infowars motion is denied to the extent that it seeks dismissal of Infowars as a defendant. On to fair use. We know what fair use is: the purpose and character of the use, the nature of the copyrighted work, the amount used in relation to the copyrighted work as a whole, and the effect of the use on the potential market. When Congress incorporated the doctrine of fair use, it intended to restate the judicial doctrine, but need not change, narrow, and enlarge it in any way. 4 statutory factors are treated together and not in isolation. They are a mixed question of law and fact. As an initial matter, defendants appear to suggest at the hearing that crafting a jury instruction on fair use to adequately explain the affirmative defense would be difficult, if not impossible. The court disagrees. The Ninth Circuit says one who is not the owner of a copyright may use the copyrighted work in a reasonable way under the circumstances without the consent of the copyright owner if it would advance the public interest. Such use of a copyrighted work is called a fair use. The owner of a copyright cannot prevent others from making a fair use of the owner's copyrighted work. Defendant contends that defendant made fair use of the copyrighted work. The defendant has the burden of proof in determining, etc., what the factors are. And then the jury instruction: if you find that the defendant has proved by a preponderance of the evidence that the defendant has made a fair use of plaintiff's work, your verdict should be for the defendant. The model jury instruction also provides a relatively detailed discussion of each of the 4 main factors and additional factors that may be relevant. On the first factor, the purpose and character of the use, there is no doubt that defendant's use of Pepe the Frog in the MAGA posters is commercial in nature. The Ninth Circuit has explained that commercial use provides only slight weight against finding fair use where the use is not highly exploitative and intended to save the expense of purchasing authorized copies. Defendants argue that the depiction of Pepe the Frog in the MAGA poster is transformative physically and contextually. As to the physical differences, defendants note that Mr. Allen used an image of Pepe the Frog drawn by a third party, not one drawn by plaintiff. He also made alterations to the shading, the shape of the mouth, the pupils, the texture to make it look more natural. Moreover, Mr. Allen only used the face, not the body. In opposition, plaintiff argues that minor physical alterations are insufficient to be transformative because the image of Pepe the Frog in the MAGA poster was instantly recognizable and was in fact recognized by defendant's employees and customers. Plaintiff provides the following side-by-side comparison. As to the contextual differences, defendants argue that Pepe the Frog is only one of 12 faces on the MAGA poster and is one of the least prominent figures in it, taking up only a small percentage of the total poster. Defendants note that Pepe the Frog is depicted as one of many political figures and alternative media members, far removed from his original context in the comics. At the hearing, defendants reaffirmed the highly transformative nature of Pepe the Frog because their use was complementary to plaintiff's use of the original character. In opposition, plaintiff correctly notes that in order to be transformative, the use of some elements of a prior author's composition to create a new one, at least in some part, must comment on that author's works. This is an incredibly important distinction. If I transform your copyrighted work in order to sell my car, or sell my cars at a car dealership, I have not transformed the work in a fair use way. I am not commenting on your original work. If I transform your original work in order to sell copies of my work because I've commented on your original work, that is closer to a fair use, at least on factor one. So this is very, very important. The transformative and commentary part isn't just any commentary. It's commentary on the original work. Plaintiff then argues that Pepe the Frog's depiction as a commentary on politics undercuts defendant's own argument that there is contextual transformation. In other words, the MAGA posters are not commentaries on Pepe the Frog himself. In response, defendants argue that Mr. Allen included Pepe the Frog in the MAGA poster to, among other things, symbolize the sharing of memes during the 2016 presidential election and express the ridiculousness that a cartoon frog had become a hate symbol. For support, defendants cite to Mr. Allen's deposition. At the hearing, plaintiffs argued that the decision to sell the MAGA posters was purely driven by profit, supporting a finding that defendants' use of the work was commercial in nature. The court agrees that defendants' subjective belief has some relevance, but is not entirely convinced that a subjective belief is dispositive. Nimmer on copyright says, commentators champion additional factors as part of the fair use calculus, and that fair use should be found for types of use that engender market failure. One frequent factor recognized by courts relevant to the character of the use is the propriety of defendant's conduct. Characterizing the fair use doctrine as equitable, it has been held that defendant's unjustified denial of its use of the plaintiff's work is a factor militating against permitting defendant to claim a fair use defense. But case law betokens that an inquiry into defendant's state of mind does not necessarily belong in fair use calculus. Regardless, the court just told you all these things and now says regardless. The court concludes that, at minimum, there are disputed issues of fact precluding summary judgment as to whether the MAGA poster's use of Pepe the Frog was physically and contextually transformative. The parties have presented widely conflicting evidence on the fair use defense that requires the court to weigh credibility and resolve factual disputes. And as already discussed, these factual disputes and credibility determination are more appropriately left to a jury. Accordingly, because of numerous factual disputes as to the physical and contextual transformative nature of Pepe the Frog, this factor does not weigh in favor of finding of fair use as a matter of law, and the jury may conclude that the factor does favor fair use. The second factor acknowledges that some works are closer to the core of intended copyright protection than others. Works that are creative in nature are closer to the core of intended copyright. Defendants argue that the nature of Pepe the Frog is somewhat unique because the character took a life of its own. Defendants argue that the memification of the character was widespread and far different than how Pepe the Frog was depicted in comics. The court disagrees because defendants have not pointed to any authority for the proposition that memification of an image or character destroys or diminishes the original author's copyright interest. Indeed, plaintiff's original creation and depiction of Pepe the Frog and subsequent creation of Pepe in Blue Shirt are creative works that fall within the core of copyright protection as discussed above. Indeed, no matter how popular a character may become, the copyright owner is entitled to guard against the unauthorized commercial exploitation of that character. But because this factor has been described as not terribly significant in the overall fair use balancing, it carries little weight. Accordingly, this factor marginally weighs against a finding of fair use. The third factor, the court evaluates the amount of the work used. The Supreme Court in Campbell explained that the third factor inquires as to whether the amount and substantiality of the portion used in relation to the copyrighted work as a whole is reasonable in relation to the purpose of the copying. The attention turns to the pervasiveness of a parodist's justification for the particular copying done, and the inquiry will hearken back to the first of the statutory factors, for, as in prior cases, we recognize that the extent of permissible copying varies with the purpose and character of the use. Defendants offer the same arguments they offer in connection with the first factor. Defendants note that the use of a single depiction of Pepe, dissimilar from the vast majority of drawings plaintiffs has made, and the use of a third party's drawing as a reference were necessary for the authorial, that's a word, were necessary for the authorial purpose of the MAGA poster. And like before, defendants also note that Mr. Allen included Pepe in the MAGA poster to comment on the use of memes in the 2016 presidential election and the prominent role that the Pepe meme played during the election. For the reasons already discussed above, the court concludes that there are numerous disputed facts that preclude a grant of summary judgment. The fourth factor is the effect of the use on the potential market. We've seen this before. As with other factors, the court concludes that the parties have presented conflicting evidence. For instance, defendant points to the fact that Pepe the Frog and the MAGA posters are not market substitutes, and that if anything, Pepe the Frog's association with political conservatives skyrocketed its popularity. Defendant also points out that it does not appear that there was any sort of delayed negative impact on plaintiff's licensing market caused by this right-wing affiliation. Plaintiff contends that he has an active practice of licensing Pepe for use in derivative works. Plaintiff also argues that Pepe the Frog's association with MAGA posters harms the market for derivative works, and that its connection is something plaintiff specifically does not approve of. Plaintiff points to his and Mr. Jones' depositions. Accordingly, this factor does not weigh in favor of finding of fair use as a matter of law, but also does not necessarily weigh against a finding. Weighing the four factors together, the court cannot conclude as a matter of law, especially in light of numerous conflicting factual disputes, that defendants are entitled to summary judgment on fair use, and that defense is therefore denied. Abandonment and implied license. Defendants argue that the public statements, as we saw above, were creating some kind of implied license or abandoning the copyright, and their motion is therefore denied because there's still a dispute as to that. Statutory damages and attorney's fees. They say that plaintiff is precluded from seeking statutory damages and attorney's fees because they have not, I'm assuming, registered the copyright. Correct. The copyrighted work must have been registered prior to commencement of the infringement unless the registration is made within 3 months after the first publication of the work. Where a defendant commits some infringing acts before registration and others after, the availability of statutory damages and attorney's fees turns on whether there is a legally significant difference between the infringer's pre- and post-registration infringement. So they argue about this for a little bit, but it looks like the timing of that is that the registration was too late. Each separate act of infringement of the same kind, like here, does not mark the commencement of a new infringement. Rather, the infringement is part of an ongoing, continuing infringement. So new sales of the poster or whatever would have been part of the original infringement, and therefore the original date applies. So summary judgment is granted as to statutory damages and attorney's fees. In conclusion, granted in part, denied in part. And the case will continue then, and the case will continue to pre-trial jury instructions, motions in limine, all evidentiary things or jury fact-finding things. And then if there's a jury trial, which I would almost never suggest you have a jury trial on this kind of thing, but either party can request it. If you have a jury trial, then jury selection and all that, and then an actual trial in open court on the merits of a copyright claim involving Pepe the Frog. I think that's pretty remarkable. What do you think?
That was a lot of words, but it was really interesting.
Well, it's going to be a lot to edit too, so good luck.
One of the things that Spellbound Tutor said in chat that I thought was relevant is when you have a defense and you kind of do this spaghetti at the wall defense where you argue absolutely everything, that sometimes your arguments conflict. And so they're trying to say that Pepe the Frog was based off of this Argentinian Pepe character, which do not look all that similar. I mean, they're both frogs and they're both named Pepe, but like, eh. But then they also try to say that the Pepe the Frog in the poster was not Pepe the Frog, that it was from a third party, that, you know, it's transformative, that is whatever. And so obviously the similarity between the poster frog and Pepe the Frog is so much greater than between the Argentinian Pepe and Matt Furie's Pepe. So I think sometimes there's a little bit of a conflict between your arguments when you do this spaghetti at the wall, see what sticks.
Yeah. I've seen judges call lawyers out on that before. Defendant can't have it both ways. And that is our show. That is the first Lawful Masses live stream for June 2019. Thank you very much to our supporters on patreon.com/ljfrench and sponsors.org/u/lawfulmasses. Thank you very much to our $50 plus supporters for the month of June. Thank you very much to John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Terry Chris, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, Aspernari, and Snorre Wisotzky. Andy says he'll be back. Maybe we can support Andy in some way. So if Andy needs our support. And then the $5 plus supporters are scrolling on the LED panel behind me. This month I made the sponsors supporters first. Next month I'll switch it back, or we'll figure out some script so that I can go back to doing it based on donation and time. But for now you're first because I don't want to neglect you. So thank you all very much for joining me today. I will have a very special video for you. We did dog pool party this week, but I don't know how much I'm going to be able to incorporate it into the outro, so we'll have that playing here then. Until next time, I will see you in the videos that drop. I am Leonard French, your favorite copyright attorney. Thank you to Tactical and Brandon and Kaylee who are here with me today, and have a great week. Love you all. Bye.